Hi, good afternoon. This is Raymond Tan from Tan and Tan Lawyers. Today we're going to be discussing what your rights are as a parent and if there's a dispute about who is going to be taking care of the children or the child when there's a separation. Now, unfortunately, once you have a child with your partner, even if you have a separation, you're going to be still stuck together making decisions about a child until the child is at least 18 years of age. So very often I would get cases where a mother comes to see me and says, look, I'm having a problem. I'm separated from my husband or my partner, and I've got this young child who's about 4 to 5 years old, and we're having a dispute about what's the best way for the child to spend time with the father. In most cases, if both parties can reach an agreement, you can actually prepare what we call a parenting plan. You can get a draft of it from the family court's website. With this parenting plan, it lists out exactly who the child is going to live with, when each party is going to have contact with the child or children. You can even cover extensive issues like Christmas Day, Father's Day, Chinese New Year, anything. Any dates that you think would be important for either parent to spend time with the child, especially during school holidays. So if there's an agreement, you follow a parenting plan. Now, the problem is if you cannot reach an agreement, then what do we do? Well, you can apply to the court for a court order outlining exactly what kind of contact each parent is going to have, or who the child is going to reside with. And that is if you cannot reach an agreement. Now, we mentioned just now about a parenting plan. It is a very informal document. It is not actually a court order. So if you want a court order to list out exactly what rights you have regarding a child, then you may need to be able to file what we call a consent order, which is a Form 11. That consent order can list out the children's detail and then set out exactly what is agreed between the parties regarding contact. So the issue is if you cannot reach an agreement and you cannot file the consent order, then you have no choice but to file an application in the family court. Now, the problem with children matters, unlike property orders, is that before you can file any application in the family courts, you need to attend a family dispute mediation process. So somebody has to organize for a mediation process. It could cost about $1,000 to $2,000 just. So if the mediation is attended by both parties by agreement and you reach a decision about how or who is going to see and have the arrangement for the children, then you file the consent order, the Form 11. If you cannot reach an agreement, then that gives you the right to go and file a Form 1 application, which is an application to the court stating exactly what the issues are, right? And for you to file that Form 1, as I said, you need to have a mediation dispute resolution certificate that you have attended this dispute resolution. Now, the only time that you are able to file a Form 1 application in the family court without that certificate is if there is a very urgent matter for the court to consider. For example, there is family violence or child abuse, or you need to bring the child somewhere on an urgent basis, or you need to seek medical attention on an urgent basis. So if things are urgent, then you may be able to persuade the court that there is no need for you to try and have this mediation conference first before filing the Form 1. Now, if you file a Form 1, Form 1 will state to the court what you want as far as the child is concerned. So if you were the mother, for example, you may say, I want to have the child live with me, and I want to let the father see the child on these days. I want to let him pick up the child at the school or at my house. Sometimes it may be that you are afraid that there would be violence. So you may say that I want the child to be picked up at a neutral place. So your Form 1 application states exactly what you want. Now, if you are the father and you are being denied contact, you may say, okay, I want a court order for me to have contact with the child immediately. and I want it to be heard as soon as possible. So it's an urgent hearing, right? So you file the Form 1 and it states exactly what you require. And the document is then lodged in the courts. The court then gives you a sealed copy, and then you have to serve the sealed copy on the other party usually. Unless, as I said, there is something that is very urgent and you do not want to serve the application and you want an urgent order to protect the situation. If you have filed the application, then the court is likely to have what we call a initial hearing, right, to find out exactly what is the issues that are being sorted out. And at this initial hearing, it could be that the courts will have what we call a case assessment conference first. So what is a case assessment conference? Well, you file your Form 1, the court tells you to turn up on this day. On this day, if it's an urgent matter, the court says, okay, before we even let the magistrate see and listen to you, I want you to go and see a social worker who's going to interview both parties to find out what the issues are. So, for example, the social worker sees the mother and the mother says, look, I do not want to give the father contact because the father has been taking drugs in the presence of the child. So the social worker may then ask the mother, okay, if that's the case, if I get an undertaking from the father that he's not going to take any drugs or consume any alcohol while the child is with him, would you agree to let him have contact? So if the mother says yes, then the social worker or the case assessment officer will then have a separate interview with the father to say, these are the issues, this is the proposal from the mother, would you agree? And if he agrees, then a draft consent could be written out to say, yes, this is what we want to do. The child will only see the father, but the father cannot consume alcohol or take any drugs when the child is with the father. So that becomes a court order. And then the court is going to adjourn the matter to a further hearing, right, which could be in another 1 or 2 months' time. So at this further hearing, sometimes the court says, okay, we've got the mom and the father arguing over all these issues. We can't understand we can't believe who is telling the truth. Perhaps we need a third lawyer to represent the interests of the child. Now, that third lawyer is the Independent Children's Lawyer, the ICL, they call it. So usually they are appointed by the courts, and then the courts write to legal aid, and then legal aid would get a lawyer representing the interests of the child. So this ICL's job is to sit down, make arrangements to look at all the files, and then make arrangements to interview the child, maybe if the child is old enough to give an opinion, or if the child is too young to give an opinion or to give any evidence at all, then the ICL may just view all the documents and then come to the courts with some submissions as to what they think is in the child's best interest. So the initial hearing that we're talking about may cover all these issues, and then the ICL is appointed, and then it will be further adjourned. And there may also be what we call a case assessment conference. So if both parties are still fighting, then the courts may decide, I'm going to get a counselor to sit down with both parents and interview them. And the consultant may be able to negotiate an arrangement regarding the future care of the child. Now this arrangement includes the opinion of the independent children's lawyers, right? Now, the consultant may prepare a family report to give to the courts to explain to the courts what the issues are and how they think it can be resolved. And then the court may say, okay, I've got all the information that I require to make a decision. Let's set it down for a final hearing. Now that final hearing is not actually a final hearing because you're only talking about a hearing to deal with specific issues up to that date. So it may be that the child is only 5 years old, there's an argument about what's to happen for the next 2-3 years. So the court may say, well, I have a final hearing just to deal with these 2-3 years. So the court has got all the information, the case assessment conferences, reports, the case information from the independent children's lawyers. Then they will have a hearing with all the parties and then make a decision as to what's to happen for the arrangement for the child. Now, if they make a final court order for that period, it is only for that period. And then the court may say, I will review this case when the child is 10 years old. So for the next maybe 4 or 5 years, arrangements that is made by the courts on that day continues. And then in 5 years' time, there will be another hearing just for the courts to decide, okay, what's happening with this matter? How are we progressing? Are the parents still having a fight, arguing over all these issues? So potentially you have to understand that as far as children matters are concerned, you could be in courts fighting over every bit of things, over every bit of information, over every bit of arrangement that you think is in your best interest of the child, right? And the matter could progress for years. And I can tell you, legally, funds that has to be paid for lawyers could range from anywhere from $10,000 to $40,000 easily if the parties are fighting about everything. So you need a lawyer who's going to be able to assist you and remain, impartial, not get too emotionally involved in the matter so that they can give you the best advice possible. So if you have any questions, give us a call at 10 and 10 Lawyers, and let's see how we can help you to make sure that the interest of your child is protected. Thank you very much.